morning case, please.
State of Tennessee versus William Andrews.
Good morning.
Morning.
John Colley of the Murray County Bar for here for Mr. Andrews. We got really two issues. One that the appellant raised on whether the consent Mr. Andrews gave the trooper at Vanderbilt University Medical Center. I'd like to reserve 5 minutes too, please. Thank you. Sorry about that. And then the state has brought up whether or not exigent circumstances could dispense with the consent requirement and serve as an exception to the warrant requirement. I want to focus on the consent first. The trial court found that my client consented to the blood draw, which underpins the impairment conviction on 2 counts of vehicular homicide. Now, I want to discuss what the record reflects happened in my client's hospital room at Vanderbilt. He's in the hospital bed at Vanderbilt. He has multiple broken ribs, 3 fractured vertebrae. He's got a large hematoma from head trauma from the accident. Hospital records indicated he was suffering from blurred vision and dizziness, and that he was still feeling foggy. And at 5 o'clock, 5 minutes before the implied consent form indicates he signed it, he was still described as confused. So that was his condition there at Vanderbilt when Trooper Olivas arrives to figure a way to get some of his blood. And Trooper Olivas was brutally honest, both the day of the accident and in court during our suppression hearing, about how this occurred. The body cam from Trooper Bush captured a phone call with Trooper Olivas after the consent was obtained, and Olivas described it, and with the court's indulgence, it's not very long. I'm just going to read his description of what he told Trooper Bush about how he got the blood, and it's in the record. So he was kind of hesitant about giving me blood until I said, "Look, bro, here's the deal. You are required by state law to give blood right now." He was like, "Why is that?" I said, "Because the person you hit has passed away. So by law, you have to. You are required to give blood." He said, "All right, I'll give blood." And at the suppression hearing, Trooper Olivas went into a little more detail about what hesitant meant on the part of Mr. Andrews, and testified, "I asked him for consent to give blood. I don't know if he nodded no, or if he grunted no, or hesitant. He was very hesitant at first. And then once somebody is hesitant, or they say no, or they are taking their time, I advise them, state law 55-10-407 requires that your license will be suspended." So this is what we've got, gentlemen. We've got a man who's not, if critically injured is too strong, let's say severely injured in his hospital bed, and the trooper shows up and asks for blood, and as the state's brief acknowledges, Mr. Andrews said no. Whether he grunted no, or nodded no, or was so very hesitant it was a no. And the trooper says, "You don't have a choice." And this is the consent. This is the consent that the trial court said was unequivocally given, was a valid consent. Now, there's no way to square these facts with the definitions that this court has given to a voluntary consent. That it must be the product of an essentially free and unconstrained choice, that it must be unequivocal, specific, intelligently given, and uncontaminated by duress and coercion. And both of those are from State versus Henry, which is almost on all fours with this case. And there's just not any way that this was free from duress. As soon as Mr. Andrews said no, he was told he didn't have a choice. Not, you can refuse, but this is happening. He was told, look, bro, you're going to give blood right now. That's the law. And that, when you don't have a choice, that's not a consent. And the trial judge put great emphasis on a recorded phone call later between Mr. Andrews and his mother, and said that he admitted he gave consent. And to be honest, it's uncontroverted that he did give consent. The question is whether that was a consent that passes constitutional muster. And the conversation, it's in the record, but the state included it at page 22 and 23 of its brief, indicates that Mr. Andrews thought he gave consent. He didn't use the word unequivocally and voluntarily. In fact, he tells his mother in this recording that the trial court relied on that he didn't even verbally agree to give blood, but just after being told whatever, held his arm out. And we would just submit, if we're applying the law to these facts, this interpretation of what a constitutional consent would be de novo. Now the facts, the state gets all the emphasis in their direction, but in terms of whether this was a knowing and unequivocal and voluntary consent, this consent was everything that this court said in Henry you can't do. You can't tell people it's the law, give me that blood. You can't do that. And this trooper, these injuries, this trooper didn't even bother to ask the nurse, how's this guy doing? Is he okay? You want to be okay? How's his mind? Is he thinking clear? Have you given him any meds yet? Didn't do any of that. And then I want to move on to exigent circumstances. The proof, which was lengthy at the suppression hearing, the state did about as good a job as they could in terms of covering all the avenues, and there were many by which the state could have gotten a search warrant. They showed how many deputies were there and what those deputies needed to be doing in terms of crowd control and trying to save lives. They brought in troopers, and they brought in supervisors, and showed that how few troopers were working that Sunday in December, what they were doing, where they were, and why they weren't available as the best they could to go get a search warrant. But according to the trial court, there were some problems. They didn't show the unavailability of any judges in Williamson County. The state did show that there were at least 2 magistrates available here in Metro to issue search warrants for Vanderbilt. But the trial court didn't buy that there was no way to go get a search warrant. And just as importantly, the trial court didn't buy that they even had probable cause to get a search warrant. That was the trial court's biggest hang-up, is that they didn't know enough to go and get a search warrant. They had somebody that crossed into the other lane and hit a vehicle head on and killed 2 people. They didn't have the smell of alcohol. They didn't have open containers. I could go on with a long, long list of what they didn't have. What they had eventually, mainly from Trooper Oliva's visit to Vanderbilt, was that this guy had mild nystagmus, which could be explained by head trauma, and that he had a prescription, he possessed a prescription for morphine or something like it. Didn't follow up with, when did you last take it? Do you have that prescription in your vehicle? How strong is it? Nothing like that, just that he had a prescription and he had mild nystagmus, which Olivas, to the supervising trooper quickly said, but that could be explained by head trauma. That's what we've got. And so we would submit there's not probable cause. Let's go a step further, and for the purpose of this discussion, assume that there was probable cause. What is to keep Trooper Olivas or Trooper Bush or any other one of the 5 or 6 troopers on the scene, if you buy the state's argument that it would have taken close to 2 hours to get a search warrant here in Nashville if Trooper Olivas was at Vanderbilt, what's to keep the state from simply using the tool that the Supreme Court gave us in 2015 and getting a electronic search warrant? What's to keep the trooper from getting those indestructible laptops that they carry and typing it up and Facebooking and while he's there at Vanderbilt? The burden, of course, is not on Mr. Andrews to show that exigent circumstances didn't work out. The burden is on the state to provide and prove an exception to the warrant requirement. In this case, they went with 2, consent and exigent circumstances, but now there wasn't any proof as to how long it would take to get an electronic search warrant under Rule 41. This happened in 2020. The Supreme Court approved that amendment to Rule 41 in 2015. And there is not one question or one witness to talk about why that wasn't possible. And all this driving back and forth from Vanderbilt down to the courthouse to find a magistrate and all that, and driving back in traffic and how long that would have taken, we don't have any of that. We don't have any of that. And the proof's just not there. The trial court spent a lot of time hearing evidence. The state went to a lot of trouble to put on proof, but trying to prove exigent circumstances in hindsight, as this court has said before, is extremely difficult.
So let's go back to consent then.
Yes, sir.
Your client signed the form, and the form's very clear that you can either consent, or if you don't, and the law requires us to draw blood, which in this case it would, we have to get a warrant. And your client signed that.
That's correct.
So, in your argument, as I understand it as well, but he's in the hospital and he's got all this, but there's plenty of testimony that he had scored a 14 out of 15 on the concussion protocol, is my term. I don't know if that's the term they use.
Close enough for government.
Okay. He was carrying on conversations. He was able to stand after and walk on his own after the accident. So I recognize what the officer said to him, but there's plenty of proof that he had enough cognizant ability to read this statement here and give consent. So is your argument that what the officer may have said to him trumps all this other stuff?
Well, I don't know about trumping the other stuff, but I think under the totality of the circumstances test, which is what we are all supposed to use, we have to look not at just the fact he said no and the fact that he said, why is that, when the trooper said, look, bro, you're going to have to give blood. But I think we also might want to look at that form that he was supposed to read. Because the form itself recites, and the relevant part is on page 19 of the state's brief, after being informed there is probable cause that you have committed a crime which requires me to submit a sample of your blood for testing. And that's not anywhere in the record, that at this point there was probable cause to arrest this man. Or that Trooper Olivas ever told him, the form says informed him that there was probable cause to believe he had committed a crime. And so right there, you've got a misstatement in the very form that the state is hanging their hat on. And I would also point out that Henry and cases since then have said that the implied consent law is not an exception to the warrant requirement. So here we've got an officer that is misstating what the law is to this man to get him to sign this form. And the last thing I'd say in the last 30 seconds is going back to the consent that's at page 23 of the state's brief, where they have set forth this consent conversation with his mother over the jail phone. And he talks about what he signed and the way he describes it to his mom, oblivious to the fact they're being recorded, is it doesn't even look like I signed it. And mother said, well, what was that on? And Andrew says, whatever I signed that night to let them do the blood draw. Whatever I signed that night. So clearly, later in jail, when he's not in the hospital bed right after the accident, he can't even tell you what he signed, and not knowing that we're all going to be talking about this later. So I think the form is important, but certainly all these other things, if you look at what a voluntary, intelligent, unequivocal consent is, the form doesn't get us there. And I'll save my last whatever I've got.
Thank you, Mr. Colley.
May it please the court, Alan Groves on behalf of the state. The defendant killed Olga and Nicholas Danilov by driving under the influence of fentanyl and clonazepam. The trial court properly denied his motion to suppress because he voluntarily consented to the warrantless blood draw. And even if the evidence preponderates otherwise, there was exigent circumstances to justify the search. Regarding consent, the defendant just mentioned that this court's review is de novo, but that's incorrect. The Supreme Court has repeatedly held that whether the defendant gave actual voluntary consent is a question of fact for the trial court. And when this court reviews issues regarding a motion to suppress, this court defers to the trial court's factual findings unless there's evidence that would preponderate in favor of a different finding with greater convincing effect. And that goes as well for all the trial court's subsidiary factual findings when it's considering the totality of the circumstances. We do agree that the totality of the circumstances is the appropriate standard here. And just to go through some of those facts that the trial court found, the court made extensive factual findings in this regard. It acknowledged that this consent occurred in the hospital room, which it characterized as a non-public place. There was a third party present, however, being the nurse, which weighs in favor of voluntariness. The court found that Trooper Olivas was not hostile when he was engaging the defendant in conversation. He did not draw his firearm. There was evidence in the record that the defendant had a prior DUI conviction, which reflects that he had some experience with law enforcement and would have been aware of what was going on and how to engage with this trooper. The court also considered his physical condition and acknowledged the evidence that weighed both in favor and against voluntariness in this regard, considering all the relevant medical evidence. The trial court also placed a lot of weight, which I think was very appropriate, on the fact that the nurse that was in the room also obtained consent separately from Trooper Olivas after he had obtained consent. She testified that it was her standard procedure that she would always ensure that a patient consented to her regardless of what they had previously stated to law enforcement, and that she would always verify that they could explain their name, their location, their date of birth before she drew blood. And the trial court placed a lot of weight on that testimony. The trial court also emphasized, as was pointed out, the defendant's jail call to his own mother, where he essentially concedes that he understood that he consented to the blood draw. And his mother was asking him on the phone whether police had gotten a warrant.
Let me ask you, if the trooper said, look, bro, you are required to give blood right now. If you would, you say that's not hostile, what would you describe that as?
So I think the best way to understand this part of the record is that the trial court made a credibility determination.
I just want to know, you said it wasn't hostile, the trooper wasn't hostile. How would you characterize that statement to the defendant?
Well, the trial court agreed with Trooper Olivas that that language was part of the trooper kidding it down.
Did the trial court say it wasn't hostile?
Yes. The trial court found, I'm sorry.
Did he find hostility? It was not hostile?
Yes, Your Honor. The trial court found that Trooper Olivas was not hostile, and the trooper explained that those types of phrases that the defendant is honing in on were really his attempt to kid it down and have a conversational tone with the defendant as he's engaging in a conversation. So defense counsel can get up here and be theatrical and say those phrases in a tone that sounds hostile, but we don't know on a cold record how he was presenting that language. So the trial court, hearing Trooper Olivas' testimony and explaining how that conversation actually went down, was in a better position to evaluate whether Trooper Olivas was being honest when he said, no, I wasn't being hostile. I was just kind of striking up a conversation, trying to kid it down so he was open and receptive to me. And the trial court said that's very understandable that you would approach that situation in that manner. And that's really the first factor that defendant in his brief has focused on, is the hostility. And I think the trial court's credibility determination just completely undermines his argument in that regard. So the second factor that he's really challenged and focused more of his attention on this morning is the defendant's physical condition. And as I mentioned, the trial court considered all of the relevant medical evidence. It acknowledged that the defendant was still experiencing pain from the accident. However, as Judge Dyer noted, he scored a 14 out of 15 on the Glasgow Coma Scale, 15 being there would be no injury at all, so 14 approaching that level. And he scored that 14 out of 15 both after the accident and shortly before the blood draw. And Ian Gray, the EMS paramedic that attended to him at the scene, he testified that someone with that level of confusion could still be coherent enough and alert and oriented to time and place to be able to carry out a conversation. And the nurse that drew the blood also indicated that with a score of 14 out of 15, which is relatively good, that he could still give consent. And there was no notation in the medical records to indicate exactly why he was marked down 1 point, but she explained that that could be something as simple as someone that's just repeating themselves a little more than they might otherwise if they were completely uninjured. So that really doesn't weigh in favor of a finding that the defendant's consent was not voluntary. We also have Deputy Dagsby at the scene, who observed the defendant standing and sitting on the gurney on his own and responding to questions by, again, the emergency responders at the scene. We know that he was alert and oriented to time and place. He was also examined a little bit after the consent was given, had a full physical exam where he checked out completely okay, and even that little bit of confusion had already resolved. The trial court also acknowledged that even though he had experienced pain, that he was on pain medications to control that pain, and there was no evidence at all that the medications themselves were interfering with his reasoning abilities or mental faculties. So there's no evidence in the record that would preponderate against the trial court's factual finding that he was in a physical condition that was conducive and allowed him to be able to consent. The defendant can't point to anything that would directly contradict that or suggest a different factual finding with greater convincing effect. So the third factor that the defendant has challenged with regard to consent is the defendant's knowledge of the right to refuse consent. And the Supreme Court has held, even though that can be a very important factor, it's not even dispositive or required. And in a Supreme Court case, the court even noted that there might be some cases where you actually have affirmative proof that the defendant admits that he knew he had the right to refuse consent. And the trial court properly found that the jail call is that affirmative proof. We have the defendant in his own words telling his mother they didn't have to get a search warrant because I let them. And so that's your affirmative proof that he had the knowledge of the right to refuse consent. Now the defendant
What about the fact, defense counsel pointed it out, that on the form that he signed, it says you've been informed that there's probable cause you committed a crime. Where is that proof that he was informed that there's probable cause he committed a crime?
So Trooper Olivas, a lot of what we know about the conversation in the hospital, again, comes from that phone call from Trooper Olivas to Trooper Bush shortly after. And him informing the defendant of probable cause doesn't appear in that like summation on the phone call, but he explained at the suppression hearing that this was not like a verbatim recitation of the conversation, that he was communicating to another trooper kind of the gist of the conversation. So the proof that we have is that the defendant signed this form saying that he was informed that there was probable cause that he had committed one of the enumerated offenses in this statute. And the defendant really does want to focus on the implied consent form, again, to the exclusion of the jail call and other evidence of consent. But again, the implied consent form itself references the right to refuse consent. It says on the form that you have the right to refuse, and if you do, there are some civil consequences, civil penalties associated with that decision. And both the form and Trooper Olivas' statements about the form were 100% accurate. Tennessee law, Tennessee Code Annotated 5510-406-C2A makes a blood draw mandatory in these circumstances when there's been an injury or fatality and there's probable cause to believe that the defendant committed a vehicular homicide or a DUI. So the fact that this blood draw was required by law, as was stated in the phone call, was accurate. It's also accurate that if a person chooses not to comply, that there are civil penalties associated with that, being the suspension of a driver's license for up to 1 year and the requirement of an ignition interlock device. So nothing in the form, at the top of the form that was read to the defendant was inaccurate, and nothing that the trooper said about the form was inaccurate. And after receiving that accurate information, the defendant chose to sign the form and say that he consented. The defendant, because there's an implied consent form involved in this case, keeps citing to the State versus Henry decision by this court. But that case really is not on all fours, because as defendant noted, that case was about the state relying on statutory implied consent as a freestanding exception to the warrant requirement. But the state has never proceeded under that theory in this case. Even though the form was used, the state has consistently maintained from day one that the defendant gave actual voluntary consent. So there's nothing in State versus Henry that would undermine our position in this case. And even if the defendant was correct that there was something inaccurate about the form or Trooper Olivas' characterization of the form, even if, let's just grant that, the Supreme Court held in Birchfield versus North Dakota that a partially inaccurate implied consent advisory does not necessarily prevent or preclude a finding of actual voluntary consent. And that's because we're under the totality of the circumstances test. So that's just one part of the totality of the circumstances. So even if there was something wrong or something confusing about that form or the advisory, the courts have held that it doesn't necessarily mean under the totality of the circumstances the defendant didn't consent. And in fact, that's exactly what this court held in State versus Hafer, which was a case from 2020, I believe. The state relied on a theory of voluntary consent, even though the officers at the scene used the implied consent form when they were obtaining that consent. And in that case, the court held that the use of the form was inaccurate, but because at the time, Tennessee law had criminal penalties associated with failure to comply with the form. Here, we're under the new law. It was amended in July 1st, 2019, I believe, and now there are no criminal penalties associated with refusal. There's just those civil penalties, such as the suspension of the driver's license. But Hafer does give a good illustration to explain how even an inaccurate implied consent advisory doesn't preclude voluntariness under that totality of the circumstances approach.
Mr. Groves, see if I can ask this in a way that makes sense. You argued a few minutes ago about a code section 55, and I can't remember the exact citation, and about probable cause. Is the state arguing that that code section means that anytime there's a vehicular homicide, that forms the probable cause to get a blood draw?
So I'll just read the relevant language of the statute. I think that would be helpful. It says a law enforcement officer shall administer or cause to be administered, and then I'm skipping some language, blood tests if the operator has been involved in a collision resulting in the injury or death of another, and this gets to your question, and the operator of the vehicle has committed a violation of, and then it enumerates several offenses, including vehicular homicide.
The reckless vehicle homicide, is that what it talks about?
I believe the statute is vehicular homicide by intoxication, but it doesn't, it's using the statutory numbers in that definition, so I don't have the language of if it's referring to reckless or by intoxication. But I think the courts have interpreted that language, though, because it says, and you have committed, well, you obviously haven't gone through a whole trial yet and been like convicted of it, but I think the courts have interpreted that latter part of the definition as meaning there's probable cause that you committed one of those offenses.
Mr. Colley's arguing, I believe, that there's no probable cause to believe that the defendant was impaired. And is this, and you're arguing, as I understand it, that this statute provides probable cause if there's a vehicular homicide.
Now, whether there's actual probable cause or not is not really relevant to consent. The only way that really comes into the equation on consent is just that you're required by law to give the blood draw if there's been an accident resulting in injury or death, and the officer believes that you have probable cause, and then that's stated on the implied consent form that you've been informed that the officer believes you have probable cause.
Well, what was the basis for the officer to believe the defendant was impaired to an extent that he could be guilty of vehicular homicide as a result of drugs or alcohol?
Sure, and I think this goes more to the exigent circumstances analysis, and so I'll just transition into that if that's okay, because I think whether there's probable cause really is more pertinent to that issue. So at the time Trooper Olivas was engaging the defendant at the hospital, collectively, law enforcement knew the following facts: that the crash was head-on, that another car swerved to avoid being hit, that the defendant had a prior DUI, as reflected by the fact that his driver's license was revoked or restricted and had been required to have an ignition interlock device. Witnesses were reporting that he was falling asleep behind the wheel, which is indicative of opiate use. And then when Trooper Olivas is actually engaging him at the hospital, he notices the slight nystagmus in his eyes using the HGN test. He has this prescription for morphine, and then finally the initial hesitation that he showed when he was first asked. This court has held that when you are showing a little bit of hesitation, that can be probative of a consciousness of guilt and intoxication. So all of those facts are sufficient to establish probable cause of intoxication at the hospital. And just to back up to the prescription for morphine thing, so it was referenced that he was never specifically asked, like, when did you take it or did you have it in the car? I believe the testimony by Trooper Olivas was he was asking the defendant, are you taking any medications? And then in response to that, it came out that he had a prescription for morphine. So I think a reasonable inference would be that possibly he had taken it because he was asked, are you taking any medications? So we do disagree with the trial court on this, on the probable cause finding with respect to exigent circumstances for those reasons. The defendant in his reply brief tries to say that some of this evidence the state or law enforcement actually didn't know at the time that Trooper Olivas was engaging the defendant at the hospital because witnesses were telling Trooper Bush some of these things after he had already been dispatched there. And I think the only factor that he's actually right about that on is the failure to apply the brakes. I went back and reviewed the record after I got the reply brief, and Mr. Pevler did say after Trooper Olivas had already been sent to the hospital that he didn't think the brakes had been applied. But as far as I could tell, that's the only fact that came in later. Trooper Bush had collected all of this other evidence that I just referenced at the time of her second phone call to Sergeant Cockrell. And she clearly states on that second phone call, which is in the video, in the record, all those things that I just mentioned, and then with the addition of the new evidence that Trooper Olivas learns at the hospital. And I think looking at both of those things together gets you to probable cause. But you don't get the probable cause until really you get that last bit of evidence that was developed at the hospital. And that's important for the exigent circumstances analysis, because this court has declined to find exigent circumstances in some cases where officers had probable cause from the get-go and then just didn't obtain a warrant. But here, this case is a lot closer to cases like Walker, or a recent case this court had a couple months ago, Reynolds, where probable cause was developed much later, either at the hospital or after the defendant had ran off and he had been tracked down. But just to run through some of the other factors with regard to exigency, State versus Mitchell is really on point here. Even though the defendant wasn't unconscious at the time of the blood draw, Mitchell talks about how an unconscious driver can cause a fatal car crash that can spawn a slew of other urgent tasks that law enforcement has to attend to. And as we mentioned, all of those factors were relevant here. The defendant had to be taken away to the hospital to get medical treatment. Law enforcement was responding to the victim's car and trying to help save the 4-year-old boy, Nicholas, trying to do what they could for Miss Danilov. They were blocking traffic. They had officers at both ends of the road. They were managing the crowd, trying to keep them away from the crash, which was necessary to both preserve evidence and keep cars from, being injured by the metal debris. So for all these reasons, we think that the trial court simply erred and didn't engage with the new case law in terms of analyzing whether there was exigency here. But we do stand by the trial court's ruling on consent, and we think that's sufficient to affirm. So if there are no further questions, we ask this court to affirm the judgments of the trial court.
Thank you, General.
Gentlemen, what the trial court actually said about my client's condition with his broken back, broken ribs, head injury, as he lay there at Vanderbilt and gave this so-called consent, was that his finding was there was overwhelming evidence defendant was in excellent physical condition at the time he gave the consent. And that's just not this case. That's not this record. And we would submit that the evidence most clearly preponderates against that finding. The idea that the implied consent form read to Mr. Andrews before he signed it or tried to sign it was 100% accurate is simply inaccurate. That's not the case. We've already discussed the first time I was up here the fact that the form recites that Mr. Andrews had been informed there was probable cause to believe he had committed one of these enumerated crimes. That's not anywhere in the record that he was ever told that. In fact, Trooper Olivas pointed out that he typically does this before he arrests anybody, goes through this implied consent thing. The idea that Mr. Andrews was simply told the prevailing law at the time, that's not true either. Ever since this state has ruled repeatedly that the implied consent law is not a legal exception to the warrant requirement. This idea that you can tell somebody that's not even arrested yet, not even under arrest yet, you don't have a choice, bro, you're gonna give blood. You don't have a choice. That's the law. This is almost an absurd conversation, gentlemen. That this man's in this hospital bed injured, severely injured. Trooper comes in, asks for blood. Patient, defendant, whatever we want to call him, says no. And the trooper says, well, you don't have a choice, bro. You're gonna give it right now. That's not a valid consent. Think about this. I mean, this is insane that we would call that conversation a valid consent. And I beseech you to go to the state's brief and look at the colloquy between the defendant and his mother and see if that sounds like he understood he was giving consent, which is the way the state just painted it for you gentlemen. He talks about signing whatever, some form or whatever it was. This is a basic criminal law question about what a valid consent is. And this consent, if we're going to even call it that, flies in the face of decisions of this court, the Supreme Court, the U.S. Supreme Court, that we can tell somebody in 2020, you don't have a choice. Give me that arm. You don't have a choice. Because motorists still do have that choice. Reported decisions in this court and the Supreme Court have said they do have that choice. You've got to go some other route. You've got to do a little bit more than hold up the form and say, I need your name right here. You don't have a choice. And that's what happened in this case. And I didn't hear one word from my adversary about why the trooper couldn't have got an electronic search warrant in this case. And we can dispense with all the driving around Nashville on a Sunday during shopping season. Didn't hear a word about it. And I would submit that in and of itself shoots down this exigent circumstance argument. Thank you.
All right, thank you, Mr. Colley. That concludes the morning docket, Madam Clerk.
Yes, Your Honor.
All right, we'll be in recess till 1:30 this afternoon.
All right.